One of the important elements when you get into the world of estates and trusts and estate planning is the concept of fiduciary duty. A fiduciary role can take on many different elements, and included in that are a fiduciary can be a personal representative of an estate, a trustee of a trust, a guardian or conservator, and various other capacities. Suffice it to say that a fiduciary is a person who is handling matters in some way, shape, or form for another individual or individuals or organization. It's important that the fiduciary assume fiduciary responsibility. And what fiduciary responsibility means is that the individual places the trust or the estate or the heirs and beneficiaries trust interests ahead of his or her own obligations. Fiduciary duty requires continuous accounting of your activities, proper management of the assets, proper disclosure of the activities, impartiality to all the heirs or beneficiaries. And impartiality means that you can't favor one beneficiary or heir over the interests of the other. The consequences of failing to carry out the fiduciary duty of a fiduciary is that they may be subject to breach of fiduciary duties. This can be in the form of a demand letter or some type of demand from an individual heir or trustee. And ultimately, if things do not get resolved, it can lead to a breach of fiduciary duty lawsuit, which will subject that fiduciary to damages for loss of profits and other types of surcharges imposed by the court. So the takeaway from this discussion is be thoughtful and careful about the selection of your fiduciary, because they assume a very important role and potentially a very high liability role, and make sure that they will ultimately serve the best interests of your heirs or beneficiaries that you designate.